Welcome to Transition Plans. I'm Bill Stalter, and in this webinar, I'm going to give an overview of our contracts for life, the financial power of attorney, a healthcare power of attorney, and a living will. And we're going to talk a little bit about signs that an aging parent might need a power of attorney, talk a little bit about the execution of documents, and we'll talk a little bit about funeral planning and pre-need.
I have been advising clients for more than 30 years on essential life contracts such as powers of attorney, living wills, and pre-need contracts. Now, it can be very expensive to go to a lawyer's office, discuss these documents, and have them drawn up. Estate planning attorneys charge by the hour, and the cost for a package of life contracts would typically be more than $1,000. So I created Transition Plan, a program that works with churches, nursing homes, funeral homes, cemeteries to sponsor senior planning seminars. By working together, we can offer the essential life contracts at a more affordable price. Again, I welcome you to this short seminar. When a question comes to mind, jot it down. Your sponsor will provide an email to use for forwarding those questions to our office, and then a follow-up presentation will be scheduled to answer all questions. We start with the power of attorney, the most widely used life contract. With this form, you assign authorities to an agent who can then act on your behalf. It is common for my clients to think they need a single general power of attorney, a form that enables the agent to make decisions for both financial matters and health care. But I advise clients against that kind of power of attorney. When putting powers of attorney into place, you'll be required to pick an agent from family members or friends. Those family members or friends have different skills and capabilities. One family member may be better suited for finances, while another family member is better suited for helping with health care. Accordingly, I recommend one POA form for financial affairs and another form for health care. I'll explain the healthcare power of attorney in a few minutes. With the power of attorney for finances, you will designate an agent to pay bills and execute documents when you are incapacitated or away for an extended period of time. A power of attorney for finances can be either durable or non-durable. The difference is the point in time when the power of attorney terminates. The non-durable power of attorney terminates when the principal either dies or becomes incompetent. In contrast, the durable power of attorney remains in force until the principal dies. Should the principal become incapacitated, the durable power of attorney remains in force. In some states, such as Illinois, the power of attorney is deemed or presumed to be durable. In other states, such as Missouri or Kansas, the form must include certain language so that it becomes durable. Most clients want a durable power of attorney so that the agent can conduct business for them when they needed assistance most. Now, younger clients will often question why they would need a durable power of attorney. Well, COVID still sends otherwise healthy Americans to the hospital for weeks or months at a time. An accident could also lay you up for months or leave you incapacitated, forcing your spouse or family to carry out your own financial decisions. Without a durable power of attorney, your family may be required to go to court to establish a conservatorship. If you or your spouse plan for extended trips away, the power of attorney will allow your agent to deal with issues that arise while you're gone. For many clients, the main motivation for seeking powers of attorney is to assist a parent. A power of attorney can be used to extend a parent's independence. Clients use the power of attorney to keep the parent's bills and taxes paid on time. The POA can be used to cancel or terminate questionable transactions or purchases made by the parent. When assisted living or the nursing home becomes a necessity, the power of attorney can be used to take over all financial decisions. COVID is more likely to cause an extended illness for a parent. That could wreck the parent's financial well-being if deadlines are missed. And while a parent may be reluctant to surrender financial independence, A conservatorship is a costly alternative that may leave all family members unhappy. Signs that a parent may need a power of attorney. Mail is often pushed aside, and bills for utilities, medicine, and taxes go unpaid. The parent has confusion about taxes and the need to file a return. There could also be confusion about Medicare options, and the parent frequently asks for help. I've also seen where the parent asks the same question frequently and becomes belligerent when reminded of that fact. Of course, deadlines are frequently missed, but you also have to keep in mind if the parent's vision or hearing deteriorates to the point that they can no longer confidently read documents or negotiate telephone transactions. If a parent's condition deteriorates to the point that they are no longer capable of executing a power of attorney, a court may need to appoint a conservator. A conservatorship proceeding is a cumbersome, time-consuming, and expensive ongoing process. A court must consider arguments of all family members, including those who may have been estranged for years. Family bickering and infighting can turn a conservatorship appointment into a costly and protracted legal proceeding, with the court appointing someone other than who the parent would have chosen. The person you select to be your agent should be someone you can trust to take care of your financial affairs. Your agent will be paying bills, filing tax returns, instructing 401k administrators, and coordinating your benefits from Social Security, Veterans Administration, or Medicare. Agents should have the patience required to spend time with you to review your financial situation. This should include going over bank and brokerage accounts, business investments, insurance, and retirement accounts. And there should be a review of your financial obligations, including monthly bills. Now, the agent could be your spouse, an adult child, a family member, a life partner, or a friend, but that person needs to have the skills necessary to make financial and business decisions on your behalf. It would not be wise to appoint an individual with their own financial difficulties or who lives too far away to assist with day-to-day decisions. Clients ask if they can appoint two people as co-agents, but I recommend against that. Many banks do not accept co-agents, or when they do, they require both signatures to the document. What I have done in some situations was to prepare two separate powers of attorney forms. I recommend that when clients go through a review of their financial issues with the power of attorney, they should create an electronic inventory of assets and liabilities, such as an Excel spreadsheet. Now, a person must be competent to execute the power of attorney. Witnesses may be asked, did the principal identify himself? Did he or she know where they were in terms of location and time? Did the principal understand the nature of his finances? Could the principal state the identity and relationship of the person to be appointed agent? Now, in execution, the power of attorney will be signed with blue ink and before a witness and notary. The witnesses need to be prepared to attest to the principal's competency. Now, power of attorney can only be revoked in writing with notice given to the agent. Financial institutions may require original copies of the power of attorney, and so therefore duplicate copies are often executed. The power of attorney cannot be amended, but rather must be revoked and then re-executed with the desired changes. A healthcare power of attorney is the legal document you use to appoint an agent to make medical decisions when you're unable to. It's critical to execute a healthcare power of attorney before an emergency happens, because you may be unable to execute a power when those medical decisions are needed most. Now, the healthcare power of attorney may also be referred to as a healthcare proxy. Younger clients ask why they would need a healthcare power of attorney. Again, COVID still sends otherwise healthy people into the hospitals for weeks or months. Most of these individuals did not have a healthcare power of attorney. Consequently, healthcare workers often have no one to consult with when making crucial decisions about the care to be given.
Without a valid health care power of attorney, critical decisions about your medical care could wind up in the hands of a doctor you may not know. Many COVID patients were placed on ventilators regardless of whether that would have been their preference. When in doubt, the hospital will provide medical care that you may not want or may not be able to afford. Putting a healthcare power of attorney in place is the first step to retaining control of the care you will receive.
The choice you make for a healthcare agent is very important. Eventually, that person may be called upon to make decisions that your family members disagree with. Your agent should meet the following criteria. They need to satisfy the law's requirements for a health agent. They have to be independent from your doctor and your healthcare providers. They must be willing and able to discuss medical care and end-of-life issues with you and your doctors. They must be trusted to make decisions that adhere to your wishes and values. They must be trusted to be your advocate if there are disagreements about your care. They must be familiar with your health care insurance options, your Medicare or Medicaid coverage, and what you can or cannot afford. A person who has the time to accompany you to the doctor appointments, and someone that is both physically and mentally capable to be your advocate for years to come. Now, you must be competent to execute or revoke the healthcare power of attorney. The execution of the form must be done before witnesses and a notary who can confirm about your competency. You cannot use your healthcare providers as witnesses. A power of attorney can be revoked only but with notice to the agent. It will differ from state to state if the revocation must be done in writing. Generally, the revocation must also be witnessed and notarized. Now, the healthcare power of attorney may need to be replaced from time to time, especially if your agent is no longer available or capable of serving. Healthcare providers may also require that your power of attorney be updated from time to time. Next, I'll discuss the living will. With a living will, you can direct the life-sustaining medical care you want and relieve caregivers of the end-of-life decision-making burdens that would otherwise occur during the moments of crisis or grief. A living will is a written legal instruction regarding your preferences. Now, a living will can address such issues as resuscitation, mechanical ventilation, tube feeding, dialysis, antiviral medicines, and palliative care. Our recommendation is to first discuss the living will with your primary physician, and when you have made your decisions, discuss the living will with your family. You may also want to discuss with your doctor a do not resuscitate order, or is also called a post form. Doctors often have these forms in their possession and may have preferences about what to use. But let a living will provide peace of mind by sparing your loved ones from making end-of-life decisions. When you have the living will discussion with your family, you should also explain your preferences or decisions regarding a funeral. Funeral planning should not be put off for your survivors to deal with. When funeral arrangements are made after death, the decision process is more difficult because of grief. Family members may disagree over your arrangements and embroil your entire family in a fight. Family members may not know your preferences and consequently make arrangements that do not reflect your values. Grief may cause your family to spend more on your funeral because they see this as their last chance to show their love and respect. Initiating a family discussion about funeral will help promote healthy grieving when the loss occurs. Pre-need contracts provide psychological benefits for family members. Making funeral arrangement decisions can be too stressful for some family members. With a pre-need contract, you can choose your preferences and spare your family members from making those decisions. Every estate plan should address funeral and burial expenses. It is common for estate planning attorneys to assure clients that life insurance or probate will take care of the client's final expenses. However, that advice can be misleading. A growing number of funeral homes do not accept insurance beneficiary assignments. Insurance companies can be difficult to work with, delaying proceed payments by months. Funeral homes also encounter problems with family members making competing claims for the insurance proceeds. A probate estate may take up weeks to set up. Funeral expenses may have to be paid weeks before an executor is appointed by the court. Some funeral homes allow for probate claims, but impose additional fees for doing so. So we recommend that clients meet with the funeral director to determine that funeral home's policies regarding payment. Pre-need contracts are the most popular method for funding funeral and burial expenses. Pre-need contracts can either be guaranteed or non-guaranteed. A guaranteed pre-need contract is one where the funeral home assumes the risk of price increases. When the contract is paid according to its terms, the goods and services described in the contract will be provided without additional cost to your family. With funeral prices increasing at 4% or more each year, the guarantee provides you a way to cap future funeral costs. There are certain expenses associated with a funeral that are not covered by a pre-need contract guarantee. Cash advance expenses are costs of services or items that must be purchased from a third party after the death. These are expenses like death notices, obituaries, clergy fees, and flowers. The pre-need contract may set aside funds for these items, but it does not guarantee what the costs will be at the time of your death. Funeral homes typically offer non-guaranteed pre-need contracts when an individual cannot afford to pay a pre-need contract in full and must pay over time. A non-guaranteed contract may also be used when the individual wants to take care of funding but is not certain what disposition to choose. The manner of disposition then can be left to the family members in the future. If individuals need to qualify for public assistance when entering a nursing home, the purchase of pre-need contracts is a permissible way to reduce assets for qualification of that assistance. If the individual's disposition preference includes a burial, pre-need contracts from each the funeral home and the cemetery may be necessary. State law will require that the contracts be irrevocable, so that the contracts cannot be canceled for a refund. Pre-need contracts that include a fund for cash advance that would otherwise have to be paid at the time of death by the family. The state will have a claim against any excess funding that may be left over after the funeral and burial is provided. The state will pursue its claim against the funeral home for excess funds if those funds are improperly paid back to the family. State law recognizes a right in each person to control how his or her body is handled after death. Laws provide for a right of sepulchre document that allows an individual to appoint an agent who will carry out the funeral and burial plans. A durable power of attorney can also give your attorney-in-fact control over the disposition of your body, but state laws give a priority to the right of sepulchre. Why a right of sepulchre? Well, it is unfortunate that the loss of a loved one can cause emotions to result in a family dispute over the funeral and burial arrangements. Children from a first marriage may feel dad should be buried with mom. Parents may disagree with an adult child's wishes to honor a life partner. Children may disagree whether mom should be buried or cremated. Loved ones may not share our commitment to the form of disposition that we have chosen for our own body. The Transitions Plan's right of sepulchre form will help you ensure that your final arrangements are carried out according to your wishes or value. Once you finalize your decisions about powers of attorney designations, a living will, and funeral planning, it is crucial to begin communicating those decisions to family and friends. By including adult children in the end-of-life discussions, the parent is helping the children become prepared for the eventual loss. If the adult children are not apprised of the life documents before there is an incapacity, there is a risk they will not be found when the documents are needed most. Transitions plans will assist you in those communications by providing an explanation about your documents and decisions, including the roles and authorities of your agents. Your family and friends will be invited to presentations about the various documents. If they have questions, those will be forwarded to us and will provide additional explanations. If you want to learn more about transitions plans, visit www.stalterlegal.com and click the Transition Plan tab at the top of our website. Each of our documents are explained on the website. The Transitions Plan website page includes prices for the package of life contracts. However, if you're participating in a planning seminar sponsored by one of our affiliated hosts, we will discount the cost of your Essential Life contracts by more than half when you take a step towards funding your final expenses. Please contact that sponsor host for more information about pricing.